Morning. Morning. Calling to order the third meeting of the Rhode Island Ethics Commission. We have a full complement today of 9 commissioners. The only real item on the agenda today is the adjudication in Ray James E. Thorson, complaint number 2023-7. Are council ready to proceed? Yes. All right, before we begin, a couple things I just want to say, so you know what's on the table. One, for those of you in the Irish persuasion, happy St. Patrick's Day. Before we came here, there had been discussion about what's to happen after this meeting. The rules provide that at the end of a hearing like this, the commission is to immediately deliberate and then make a decision on the record. We received a request from Mr. Thorson's counsel to submit post-trial memorandum. The prosecutor didn't object but didn't agree. I ruled that they would be permitted to submit post-trial memorandum. As a result, the prosecution will also submit post-trial memorandum. Memorandums will be due April 1, and there will be no reply memos. We're going to determine a date for the deliberation. I think we'll ask for closings today, unless you think that's a bad idea. We could do that next time as well. And the commission is going to have to figure out a date that's going to work for all of it. Because the rules require that everybody who wants to be part of the decision-making process has to have sat through the entire proceeding. I think with that, I'd like to turn to our counsel to.
All right, good morning. The commission is conducting an adjudication hearing in the matter of Ray James E. Thorson, complaint number 2023-7. The hearing is being conducted pursuant to Rhode Island General Laws 36-14-13 and the commission's regulations. The chair as presiding officer will read aloud of the findings of probable cause, and the respondent will then either admit or deny such findings of probable cause. As there were 3 findings of probable cause in this case, there are 3 counts. The respondent may waive the reading. There exists by statute a presumption of innocence on the part of the respondent, and the prosecution bears the burden of proving, by a preponderance of the evidence, that the respondent has committed a knowing and willful violation of the Code of Ethics or the procurement statute as to each count. Both parties, through their attorneys, will have the opportunity to make opening statements, present sworn testimony through their witnesses, and cross-examine the other party's witnesses and offer exhibits into evidence. The prosecution will deliver its opening statement first and present its case first. The respondent may defer giving his opening statement until after the prosecution has presented his case. Any stipulations that the parties may have entered into as to exhibits or facts or other matters will be presented to the commission by the attorneys. The agreed upon exhibits, if any, will be pre-marked and entered into evidence accordingly. The attorneys during the hearing may read from or direct the commission's attention to any exhibits which have been admitted into evidence. Exhibits not agreed to may be offered into evidence by the parties separately. The prosecutor will call his witnesses, who shall be sworn into prior to testifying by the court reporter. Witnesses may choose to affirm. As to each witness, there shall be direct examination by the prosecution, followed by cross-examination by the respondent, then redirect examination by the prosecution, and recross-examination by the respondent. Commissioners may also ask questions of the witnesses. These should be clarifying questions. At the conclusion of the prosecution's case, the prosecution may then begin to present his case. If the respondent deferred giving an opening statement, it will be made at this time, followed by the calling of the respondent's witnesses, if any. Please note the respondent is not required to call any witnesses or present any exhibits, as the prosecution bears the burden of proof. The respondent, as the chair has indicated, has requested that this hearing be continued After all the evidence has been submitted today for the purpose of submitting a post-trial memorandum, the respondent also requested permission to present a closing argument after the memorandum is submitted. The prosecution did not join or object to this request. The chair has granted this request. Therefore, the parties may each file a post-trial memorandum on or before April 1, 2026. There will be no reply memos, as the chair indicated. This hearing, therefore, will be continued to a date to be determined later this morning. On that date, the commission will consider the memorandum and hear closing arguments from the parties. The commission will then go into executive session, conduct deliberations, and then return to open session and vote as to each count. There will be no motions or votes in executive session, but that's for the next hearing date. As the respondent requested the continuance, the respondent agrees to waive any and all claims he may have for the commission, not deliberating immediately at the conclusion of today's evidentiary hearing. Mr. Bristow, could you confirm that you are making that waiver, please?
Yes, I can confirm that. Thank you.
Thank you. Only the commissioners who attend all of the adjudication hearings may deliberate and vote. Commissioner who is not present for the initial determination, probable cause, or motion hearing, but is present for all the adjudication hearings, may deliberate and vote.
All right. We've been presented with stipulation of agreed facts. How do you, are you considering having been submitted to us now? Or you want it marked in some way, or I don't want to mark it as an exhibit out of order. You have provided us with a list of exhibits, or at least we're aware that you have a number of exhibits. So I don't consider this an exhibit, and as far as I'm concerned, unless one of my fellow commissioners has an issue, I consider it having been submitted to us and part of the record already.
Please, the commission, my preference would be to have that stipulation entered as a joint exhibit, just to make sure that it's part of the record, both for the commission and on appeal if necessary.
Yeah, it makes no difference to the respondent, Mr. Jones. You know, it's court, it would be just entered as a stipulation between the parties.
I know.
Yeah, but
We'll call it joint exhibit one.
Whatever you want to do.
Listen, say.
Thank you.
As I understand how things are going to proceed, the next part of this will be for the prosecution to present the exhibits that it wishes to present. So Mr. Briscoe's objections, I should note that we had a substantial hearing on March 3rd, in which we went through a number of objected to exhibits. There were some rulings made at that time. Don't know to what extent we'd have to revisit those rulings. We have some exhibits that were not presented at that time. We'll start in and see what we need to do here. I'm not convinced we need to revisit the rulings fully. We have to put on the record what we've done, but we did hear a substantial argument on March 3rd about what's coming through us.
So is it fair to say that the respondent has no objection to the rulings?
What? I missed the question.
Is it fair to say the respondent has no objections to the rulings we made? At this
Well, we
stage?
know he has objections
Well,
to the ruling.
at this stage.
you know, at this stage, I would repeat and ask to incorporate into the record the objections that we made, both in writing as well as before all of you on March 3rd.
We're going to go through these one by one as well, so I presume you will renew your objection as to each one as it comes. Unless you want to completely incorporate it, prosecution's accepting the incorporation of the March 3rd rulings. We do have an order on that here. Excuse me. But my impression was that we were going to be presented exhibit by exhibit. We have books of the exhibits before us. I've asked the commissioners not to review the exhibits until we know what's in. And again, I guess the question comes down to how much we need to do relative to the exhibits that were admitted, or at least were not stricken, or whatever the word would be, precluded on March 3rd. I do have to do one thing according to my trustee counsel, if there which is, I need to read, unless you waive the reading, I need to read the charges, unless you waive the reading.
We'll waive the reading. We know what the charges are.
Thank you.
Thank you. Appreciate that.
So all that being said, I guess the next step is to suggest to Mr. Grammett that you present your exhibits.
Thank you. For the exhibits, I plan to move that the exhibits be brought into evidence as full exhibits in different tranches based on how they were handled at last week's hearing. So, for instance, my first motion is going to ask that you accept those exhibits that I previously provided to opposing counsel and to which they did not object in their motion to exclude. So my assumption is that there's no objection to those exhibits in it, and those are, just for the record, and they're numbered the same as they were the last time, but now there's a P for prosecutions sitting in front of them. So those will be P1, which is James Thorson's statement, P2, which is his 2023 financial disclosure statement, P18, which is an email, P19, another email, P20, another email, P22, an email, P23, an email and an attachment, P25, an email, P32, the affidavit of Lindsay Scanapico, and P33, the affidavit of Everett Abbott Buller. As I said, these exhibits were previously presented to opposing counsel and were not included in his motion to exclude that you heard last week. And I move that they be treated as full exhibits at this point.
Any objection?
No objection. Thank you.
Thank you.
Thank you very much. Next, I would like to move into evidence as full exhibits, those exhibits that were included in the motion to exclude last week, but for which the commission denied the motion to exclude after our full hearing and argument last week. So those exhibits are exhibits P3, the Department of Administration webpage, P4, a job posting, P5, a Department of Administration request for proposal, P6, Scout's proposal, P7, the agreement for pre-development services, P8, including sub-exhibits A through K, which are invoices from Scout to the state, P9, which is an email thread, P10, email, P11, email, P13, email, P14, email, P15, email, P16, email thread, P17, email thread, P28, text message, P29, text message, and P30, a memorandum regarding the Bach site visit from David Patton to Director Thorson. Again, all of those exhibits were included in the motion to exclude. The commission denied the motion to exclude after hearing from both sides and briefing. And I would ask that those exhibits today be entered into the record as full exhibit.
Mr. Bristow.
There are two things. One, I would renew our objection, the respondent's objection to each of those exhibits. I'm not going to rehash what we discussed on the third, but I believe that the basis for doing so are appropriate, and the commission has made a determination that they denied a motion to exclude. But having said that, the exhibits, I believe, are objectionable and should be excluded by the commission. And the second part of this, and I may have misunderstood this, is I thought the exhibits would be offered in connection with the testimony of any witness in this case. For example, exhibit 3, I guess, which was the first one, that would be shown to a witness, deemed relevant somehow through the witness's testimony, not the explanation that was given by the prosecutor on the March 3rd hearing, and that would be offered the commission would have already made a determination, at least as to the evidentiary basis for which we objected. But that's how I thought we would proceed. I didn't know that these exhibits would just come in en masse without being tied to a particular witness's testimony.
Mr. DeSimone, any thought on that?
Yes, some of the exhibits, I think, certainly do not need the testimony of the witness because I think they have the certifications from the keepers of the records. There are some witnesses, some exhibit, without going through all of them, there are some exhibits that may be better left to, be offered during the testimony of, I think is Mr. Thorson the only witness today? That's my understanding.
That's the only witness I intend to call. Could I respond?
Sure.
So, notwithstanding, that understanding, I thought it was very clear at last week's hearing that these records, my argument then and continues to be, they are all self-authenticating as government public records, without the need for direct testimonies. Take it straight from the rules of evidence. But again, we're under more relaxed rules. So even under the rules of evidence, there's no need for direct testimony for these. These are all certified public records. But then again, under the much more relaxed standards of the administrative hearing, they're all admissible without direct testimony. And I want the commission to have them available as part of the record when you're considering oral argument or post-trial.
I just get a clarification. As part of this group, when certain exhibits were proposed, the prosecution conceded that they were not being offered for the truth contained therein. Does that apply to this group?
I'm not certain that we're talking about everyone in this group. Certainly, we're about to get into the deferred exhibits, including the email from Scout to the governor's office. And when we get into that, I will be renewing that argument that it's not being offered for the truth of the matter asserted, among other arguments.
I thought that there was a wider assertion, if I can direct it to legal counsel, of that concession.
As I recall the hearing on the third, I think Mr. Graham is correct in that his assertion that the documents weren't being offered for the truth asserted therein related to the emails that the commission deferred ruling on. Specifically, the one I remember mostly was the email that was forwarded from Grit to Mr. Afonso.
And it may well be, Your Honor, that some or all of these exhibits won't be introduced for the truth of the matter asserted, but that will come through in my closing statement and in my post-trial memorandum, and ultimately up to you to decide what purpose it was submitted for and why that you are either relying on it or not relying on it.
Well, continuing to think on this, I think there are a number of emails going back and forth having to do with invoices that were outstanding from Scout. So I'm not sure if Mr. Gramick his position is that he's offering those exhibits to establish that the amounts reflected in those invoices was the actual amount due and owing. Or that there was just an issue as to outstanding invoices being owed to Scout, not necessarily what the amount of the invoices was. Is that correct?
Some of the evidence in these exhibits are email from Scout indicating that there are outstanding balances due under their redevelopment agreement. That is correct.
There's also stipulations here without assuming that.
So I think that Mr. Bristow is distinguishing between authentication and relevance. I think that under the circumstances and with the rules that we apply, unless any commissioners disagree, we'll take the exhibits that we denied the motion on the third. To the extent, Mr. Bristow, that they've been admitted full, I still will accept argument when they're presented about relevance. Because I think that the question of relevance has to be considered by us at some point in terms of whether we actually rely on exhibits or not. Okay, fair enough.
I think I need to respond to what, Mr. Graham had said, if you don't mind, Mr. Chair. I think, just Senatori's, recollection regarding some of these exhibits, not all, but some of these exhibits not being offered for the truth of the matter contained therein wasn't limited simply to the Brit, to, Fonzo email. That's my recollection. The second part, I think that's concerning for me is, I think Mr. Graham had just said that the commission will know which ones are being offered for the truth, not being offered for the truth of the matter contained therein when they listen to his closing argument and read his memo. And I don't think that's how it works. I say it very respectfully. I think that the commissioners, as they receive this evidence, as they hear any testimony relating, need to know if there is a limitation in how they can use it, they need to know it at that time. And that's, so I don't think that's appropriate what counsel said.
Well, and that's why I suggest to you that when the evidence is presented, you have a right still to object to relevance, which will either bring out the response from Mr. Graham, or he'll have a different response. And we'll find out which exhibits are being offered, not for the truth, but for the fact that they haven't.
And I appreciate that, but I thought what Mr. Graham had said was that these exhibits were being introduced en masse and may not be used with witnesses. And they may simply, they're exhibits that are now admitted in evidence before the commission. I mean, when I first stood up, I said, I thought these exhibits were going to be shown to witnesses, their relevance explored, and then, and then offered with the understanding that argument has already been held on the evidentiary basis for excluding them. So again, my only, and I'm not trying to disrupt it, but my issue with what you just said is that if all these exhibits, which is a good number of them, are introduced en masse over our objection, they're in. And, the concept of, well, listen to what I say at the end or read what I say at the end, and then know which ones I offer for the truth of the matter contained therein or not. I just don't think that's how any trial I've ever been involved in works. And I do have one other thing I wanted to bring up so I can get it out, Chris. The other thing that the prosecutor said was that these are all public records because we have these authentications. The rules of evidence only allow them to come in if they're public records, as public records, under the criteria established in Rule 803-8. I mean, we argued that, I'm not gonna re-argue it, but we argued that 2 weeks ago. The certifications are just authentications. Yeah, and that's Rule 901 and 902. We discussed that the last time we were here. But the certification simply means that they're authentic, but they have to be admissible under one of the other rules. You just assuming the rule to the extent that the rules are followed in this administrative proceeding. So I'm going to renew my objection that these are public records, as that term is used in the rules of evidence in the state.
And you made that argument a lot last time we were here. I'd like to ask counsel what you think about this.
Well, there are a number of exhibits that are discussing there. And it's obviously very difficult to when they're being offered and as a group, it's hard to discern or determine whether what all of these exhibits actually are. And whether or not there is an argument as to relevance, as to whether or not they're relevant, whether they should be admitted, notwithstanding they're properly authenticated and certified. So I think it actually would be best for the prosecution and the respondent, if the respondent is going to be offering exhibits into evidence, to offer them one by one, and the commission can consider them one by one.
That's excluding the ones that have already been agreed to today.
Correct. Mr. Bristow, you did agree as to the first group
Yes, I
of them.
did. Yeah.
So we're just discussing now the ones that were the subject of the March 3rd hearing.
That were denied.
The ones that were
denied.
denied, right?
Let me say now, I forgot to do this at the beginning. We may be here for a while. I intend to take reasonable breaks at different times, but I also want to say to any of the actors and players here, if you need a break, let me know, because I don't want anybody uncomfortable here. as I say, we'll be here a while, so let's all be aware that if you need a break, just. You know,
So the objections are on the record from before, they're continued, you heard argument on them. I have a concern that if we go through exhibit by exhibit, they're going to be here repeating the same arguments on the record again. So I don't know that that's the most expeditious way and fair way to do this hearing. We might get really going around in circles, chasing our own tail. I don't think that you've preserved the objections. We know what they are. If for an appeal purpose, they're there. I'm confused as to why we need to treat this like, personally, confused as to why we need to treat this like an actual civil trial. It's an administrative hearing. Oftentimes documents are admitted to the record in administrative hearings that don't go through, proffering for the witness and verification, relevancy, all those things. So if we think that the rules of evidence apply strictly, then yes, but I think that we've heard argument and taken a position that they do not. So I don't know why we would rehash this.
let me ask the question. Mr. Rahman. I think what Mr. Bristow is saying is that his ability to object to certain exhibits is not able to be done for the ones that aren't ever gonna be presented actually to a witness to go through. Is that your point?
Yes, in part, yes, yeah.
So I guess I'll say of these exhibits that were denied on March 3rd, are there any that are not gonna be presented to a witness?
Yes,
How many of those?
I don't know until I get into my testimony. I do have,
Commissioner Ritchie?
Yeah, but in all fairness, both Mr. Bristow and to Mr. Brandon, the fact that you're now going to be submitting memoranda at the end, you'll have an opportunity at that point to impress, who you're trying to impress on this issue. So perhaps that may be the saving grace.
Yeah, I can. I don't know if we're in motion territory, but I would make a motion that we proceed with admitting these exhibits.
As a group.
As a group in full, the exhibits that were objected to, but tonight after the hearing on March 3rd, admit them into the record in full.
I'll second that motion.
So I have a motion, I have a second. Excuse me. The motion is to accept as full exhibits, all of the exhibits for which Mr. Thorson's motion was denied on March 3rd. Roll call vote. Commissioner Susie.
Aye.
Commissioner Peterson.
Aye.
Commissioner Browner. Aye. Commissioner Callahan. Aye. Commissioner Summerini.
Aye.
Commissioner Ravinder.
Aye.
Commissioner Ritchie.
Aye.
Commissioner Strauss. Aye. And chair votes aye. So we'll have those exhibits in full. I think Commissioner Ritchie's point is well taken. That in terms of addressing relevance or other issues you have. No, I don't think you need to rehash everything you did. You certainly have an opportunity to address those issues. So. I think that leaves us with. The four deferred exhibits.
I do have two additional motions on exhibits. Mr. Chairman. The first, before we get to those exhibits, leave those for last. I do have three additional exhibits that I had pre-marked that were not before you at the last commission hearing, at least not as exhibits. And these are the actual certifications that I received from the governor's office, the Department of Administration. You saw those at the last hearing, but they weren't offered as exhibits. I'd like to have them offered as exhibits to become part of the record for you and for any other court that ever looks at this. And there's a third certification that I got from the Rhode Island Ethics Commission to certify Mr. Thorson's 2023 financial statement, which is already a full exhibit before you. I just had the Ethics Commission certify it as a record that it maintains, and it's a true and accurate copy. So I don't know that there will be any objections you could ask. But I would move that those three certifications with their lists attached should be introduced and accepted as full exhibits.
There's no objection.
Thank you.
So what numbers are those gonna be?
Those will be P34, which is the certification of the Rhode Island Ethics Commission. P35 is the certification of the Rhode Island Department of Administration. And P36 is the certification of the Rhode Island Office of the Governor.
And have those been presented to us in these books?
Yes.
Actually.
Finally, that leaves us with the 4 exhibits. I should mention, I'm not moving the 2 exhibits where you granted the motion to exclude. I'm not re-arguing them. I'm not asking that you reconsider today and put those back in. We'll see what happens with them, but that's not part of my motions today. So to deny or you granted those 2, they're excluded. But as to the 4 exhibits that you deferred decision on, and those would be exhibits 12, 21, 27, and 31. A couple of things. First, as to exhibit 12, which is an email thread. And if you recall, that's the one where there had been some redactions from the Department of Administration included, and there were questions about that. I have reconsidered that exhibit, and to save us time today, I'm withdrawing that exhibit and not asking that it be introduced as evidence today. So that is P12. I withdraw from consideration. That is not going to be an exhibit today that I offer. Hopefully that saves us a little bit of time. Not the time is the most important today, by the way. Then, so that leaves 3 exhibits, which is actually 2 exhibits, because exhibit 21 and 31 are identical. The difference between them, and the reason I want both of them to come into evidence, is because one of them was certified to us from the Department of Administration. One of them was certified to us from the governor's office. And I would like them both to become part of the record because I have a feeling that those 2 exhibits, which are the email that Scout sent to Jeff Brick, sent to Tony Pafonso, I have a feeling that those, should they come into evidence, will be the subject of future argument and litigation. And it is relevant and important to me to be able to show that I received them from 2 separate state agencies. So that's 21 and 31. The other exhibit, 27, are 2 emails, both authored by James Thorson. So these are not hearsay statements. These are, it's 2 separate emails sent on the same day from Jim Thorson to his subordinates. And highly relevant to what we're doing today. So I would ask that the commission, which has deferred decision on those, that now you make that decision and enter them into evidence as full exhibit. Those 3 exhibits.
21, 31, 27. Mr. Bristow.
Yeah, I thought that the commission decided after hearing extensive argument on the 3rd that it was going to wait until testimony involved in the case and make a determination as to whether or not these would be admitted as exhibits before the commission. I mean, I didn't hear anything from counsel that he didn't argue 2 weeks ago. I don't have anything to argue before you that I didn't argue 2 weeks ago. And it was my understanding that these were deferred with the understanding that, not that they would be re-argued today, after 2 weeks of pondering them, I guess is what I'm hearing. But that there would be, that we would take testimony, and if there was a time for them to be offered as part of that testimony, the commission at that point would be in a much better position to ascertain whether they're relevant to your decision-making process in this matter. That's my recollection.
Let me just ask you about number 27, because that's a email authored by Jim Thorson. In fact, it's 2 emails, it looks like, from Jim Thorson. Relevant or not, at the moment, is there any question about their authenticity?
No, not,
So. I mean, I'm inclined to take 27 now, unless a member of the commission disagrees. 27, because it's authored by Mr. Thorson. Is admissible at this point. I think 27. Do I have these wrong? I'm sorry. I have them wrong. 27 is the one that Mr. Thorson authored. I think that one makes sense to be accepted. Okay. And then 21 and 31. I think it makes sense perhaps to follow Mr. Bristow's approach on that one.
I agree.
And let testimony start, and then we'll see where we are with that. We will,
Very well.
okay. So, what with the exhibits now?
So 27 is submitted.
27 is admitted on my ruling, I think I have pretty much agreement with it. And 21 and 31 will be subject to testimony.
Yes,
That's the end of the exhibit discussion.
yes.
So, yes,
I apologize.
that's all right.
We have submitted, 5 exhibits, RA, RE, R for respondent, alphabetically, for the respondent. And, I don't believe there's any objection, I could be wrong, I wasn't directly involved in this, but, my understanding is that there's not an objection to those being, those photos of, with no objection.
So we will take exhibit RA, that's the back of your book. Exhibit RA, exhibit RB, exhibit RC, exhibit RD, and exhibit RE as full exhibits. By agreement. Anything else on witnesses? Your Mr. List, you care to make an opening statement?
Do you go first? Yeah.
I'm sorry, process first. Well,
Is that it for the so-called housekeeping matters?
I have nothing further.
opening statement. You do not need to stand if you prefer to sit.
It's okay with you. I'll start standing and see how long that lasts, but I don't intend to take that. Good morning, commissioners. The commission. I'm Jason Grammett. I'm the chief prosecutor of the Rhode Island Ethics Commission here today, representing the people of the state of Rhode Island as we define. You know a lot about this case, and you know why we're here today. The way that this adjudication has been set up, today is the day for you to get your evidence. And then a future date will be the day for you to decide what that evidence means. So my job today, as you have just seen, is to get as much evidence before you as I can, so that you can make the decision. I don't get to make that. So I'm the conduit for your evidence, then you will make that decision. What an opening statement is about is for me to tell you what that evidence is going to look like that I'm going to introduce today, and to give you somewhat of a roadmap as to where I'm going with my introduction of evidence. I'll make arguments about what that evidence means next time I stand before you in April. So this case, as you know, it revolves around a trip to Philadelphia by two state officials. One, the director of the Department of Administration, and one of his subordinates, who traveled to Philadelphia to conduct due diligence on a state vendor, a current state vendor, and a state vendor who was hoping and lobbying the director of administration for a future, much more lucrative state contract relative to the renovation of the Cranston Street Armory, which is a state-owned building that is under the supervision of the Department of Administration through one of its divisions known as DCAM, or the Division of Capital Asset Management and Maintenance. So today, with the facts, we are going to focus on this case being about a lunch. It is about a lunch, but in order to understand what the lunch was about and how the lunch fits into the 3 counts that you're familiar with from the probable probable cause finding, we have to look at a few aspects of that lunch. First, we want to know who attended the lunch. We know that 4 people attended it. So some of the facts that we're going to show you today have to do with each of those 4 attendees. Who that person is, where that person fits in state government. But most importantly, what are the power dynamics among these 4 people who attended the lunch? Who held the power? Who was looking for something from someone who held the power? And the facts, the exhibits, and the testimony that we consider today are going to go to those issues. Next, we'll talk about what happened during the lunch. And to understand the lunch, you know, it might be really easy to think, well, all we have to do is focus on that 45 to 60 minutes where people sat down and had lunch. But to make sense of the lunch, we need to place that lunch in a timeline. And not an extended timeline of years or months, but a very limited timeline that begins the day before the lunch, when Director Jim Thorson found out that he was going to have the lunch at Irwin's Restaurant in the building managed by Scout, the vendor. That's the day before. That would be a Thursday. The lunch is on a Friday. And then what happened between that lunch on Friday and Sunday, 2 days later, when the Director of Administration decided he needed to pay for it. It is not in dispute that lunch was had on Friday and it wasn't paid for on Friday or Saturday. And it's not going to be in dispute that it was on Monday, so 3 days later, that Jim Thorson reached out to Scout to make arrangements to pay for it. It will be important to consider the facts that I'm going to offer as to what happened in that interim time period. Day before lunch, lunch, the day after lunch. So let's just talk for a moment about who the 4 people were that were at the lunch. One is the Director of Administration, who sits at the top of that Department of State Government. The Department of Administration is sometimes called the back office of state government. It handles all the administrative work of the executive branch of state government. And so what's the administrative type work? Well, there's personnel and human resources. So there's a personnel division within DOA that has its own chief or director that reports directly to Jim Thorson. There's a Office of Management and Budget, and this is the division of DOA that sets the state's budget for the governor. And there's a division chief or director of that division also that reports directly to Jim Thorson as director. Oh, there's a revenue department that handles taxes, also reports to the director. There's a purchasing department that handles all of the state's contracts with vendors, including the one at issue here. And it will be important for you to know that the Director of Administration is by law, by statute, the chief purchasing officer of the state of Rhode Island, with statutory authority to approve every single contract. And finally, most relevant to today, there's a division called DCAM, the Division of Capital Asset Management and Maintenance. And that's the division of DOA that manages state properties and state leases. The lease in this building, for instance, DCAM is involved in. The State House and the Capitol and the Cranston Street Armory is a state-owned building. And the DCAM division has its own director. And that director has one direct report. And that is to the Director of Administration, Jim Thorson. So, in fact, by statute, the Director of Administration has the authority to hire these division directors, including the DCAM director. We'll include that in post-trial summary, statutory citation. So that's who one participant in the lunch is. Jim Thorson, Director of the Department of Administration, member of the governor's cabinet, appointed by the governor with the advice and consent of the Senate. The second is that DCAM director that we just mentioned, David Patton. David Patton was hired in 2022 by Jim Thorson as the director of administration. So again, the direct subordinate. And we're going to get into evidence as to how Patton and Thorson interacted relative to Scout, what the facts are relative to this entire trip, how it came about, and how the lunch was arranged. Those are two of the participants. The other two participants are the representatives of this state vendor, Scout. So Scout, sometimes called Scout Urban, sometimes called Scout Limited, but we're just going to call them Scout, is a Philadelphia-based company that has experience renovating a sprawling public building in Philadelphia. I believe it was a former vocational school known as the Bach Building. And they converted it from a former school into a place with offices and manufacturing, light manufacturing and crafts and makerspace and small offices for nonprofits and restaurants. And so it was relevant that they had a history of doing that in their proposal to renovate the Cranston Street Armory. And their proposal was consistent with what they had done, not identical, but consistent with what they had done in Philadelphia at the Bach Building. The two principals of Scout are two people whose names you will see over and over again. There's the primary managing partner and owner, Lindsay Scanapico, and there's the director of development, Everett Abbott-Horrell. So Lindsay and Everett are the two Scout representatives that are dealing with the state of Rhode Island. And what they're dealing with them on is their proposal to handle the redevelopment and the renovation of the Cranston Street Armory. They were selected for this job under the Raimondo administration before the respondent was hired as the director of administration. But there were no contracts entered into. They just had responded to a RFP. They had given a proposal. Their proposal was selected as the best one. But there was nothing going on. So shortly after the respondent hired David Patton to head DCAM, David Patton was tasked with getting this Cranston Street Armory thing going and met with the Scout representatives and entered into a contract between Scout and the Department of Administration and its DCAM division. And this is the agreement for pre-development services, where Scout was paid $400,000 over a 4-month period. And during that 4-month period, the idea was for it to come up with its master plan. Here's what we're going to do. Here's the big contract that we're going to do to develop the Cranston Street Armory. And it would make that proposal at the end of the 4 months. And at that point, the state had two options. It could either agree, that's a great idea, let's move forward and sign a new master agreement. Or the state could say, we don't like it, we're going to terminate our agreement with you and go our separate ways. But written into that initial contract was a clause that said that if the state hesitated in making one of those two decisions, it would continue to pay Scout $25,000 a month until it pulled the trigger on either moving forward or terminating the agreement. So at the time of the lunch, we were post that 4 months. The proposal had been made and Scout is now billing the state $25,000 a month and wants to continue billing the state $25,000 a month. And in fact, Scout and DCAM are talking about a 6-month extension to that $25,000 a month. And Scout is actively lobbying the state to enter into this new master agreement, which will require a capital infusion from the state of Rhode Island, multiple millions of dollars that need to be budgeted in the very next fiscal year budget, FY 2024 budget. So we're in January, February, March of 23. That's when the 24 budget is being decided. What we find out is that the money is not in the budget that is put together by the Department of Administration. But there's a chance that there could be a budget amendment. And then you'll see in the evidence that there's discussion of $15 million being added to the FY 24 budget in order to fund Scout's proposal. That is why Jim Thorson and David Patton went to Philadelphia to do due diligence to determine whether Scout could pull it off, whether the state should make that budget amendment and sign the new agreement And so let's go and see what they did with the Bach building. You get a drink of water, wind it down, I promise. And so. That's the reason for the trip to Philadelphia. We know a couple things about that lunch in Philadelphia. We know that Director Thorson instructed his subordinate David Patton to arrange that tour. So it was Thorson's idea for them to travel to Philadelphia, and he instructed his subordinate David Patton to contact Scout to arrange for the tour. We know that David Patton did that, and as part of that, demanded lunch at Irwin's. Was told Irwin's isn't open for lunch, said make it happen. Now, we don't have, and I'm not going to present you with any evidence that Jim Thorson demanded lunch at Irwin's or told David Patton, make sure we have lunch at Irwin's. So you're not going to see any evidence of that. But what you are going to see evidence is that Jim Thorson knew he was having lunch at Irwin's. That the day before lunch, he received 2 separate emails from Scout informing him that you're going to lunch at Irwin's and saying, this is from Scout, as we prepare for your lunch at Irwin's, do you have any allergies? And we know that Jim Thorson received that email because the next morning, as he was entering downtown Philadelphia, he responded to it and let Scout know that he was allergic to calamari. We also know that the day before, Scout had emailed Jim Thorson to say, here's a copy of your itinerary here tomorrow. And you're going to see that itinerary. And it will include a tour of tenant spaces. And it will conclude with lunch at Irwin's with head chef Michael Ferrari. And we know that Jim Thorson received that email because, again, within moments of responding to that prior email, he responded to this one too, to let them know that they should be on time. So Jim Thorson knew he was going to have lunch at Irwin's as he was touring. The evidence is also going to show that both during that tour and from the night before, Jim Thorson was aware that his subordinate was not acting appropriately. David Patton, in an email prior to the trip, admits and apologizes for being obnoxious during a staff outing at a restaurant. Jim Thorson has described David Patton's conduct as not representing the state of Rhode Island very well during that tour. So there was an awareness of Jim Thorson that the evening prior to this trip, late at night at 1 a.m, David Patton is sending emails when he's due on a plane in 5 hours, calling his own behavior obnoxious. And then during the tour, Thorson admitting in his statement, which will be one of your exhibits, that during the tour, Patton was not behaving appropriately, not representing the state of Rhode Island. It presented a dilemma. And that is what he stepped into at lunch. He's at lunch with his direct report subordinate, who he is responsible for supervision and discipline over, the person he hired. That's one participant. The other 2 participants are people who are desperate to continue with their $25,000 a month payments, some of which are outstanding and overdue, and actively lobbying for the new, much bigger multi-million-dollar contract. And it's under those circumstances now that you can focus on the lunch and know that at the conclusion of the lunch, no bill was brought out. No bill was presented to the table. The evidence will be that the person in charge of those 4, the person who had all the power of those 4, didn't ask for a bill, didn't say what's taking so long for the bill to come, didn't ask Scout, are you paying for this? Can I contribute to this lunch? That's what the evidence is going to show. Instead, got up, they left the restaurant. Shortly thereafter, they left the city of Philadelphia for the airport, flew back to Rhode Island. And that's Friday, and no discussion of paying a bill. Saturday, no discussion of paying the bill. Sunday, the evidence will show that Sunday afternoon, the director of administration is contacted by the governor's chief of staff and told, I received an email from Scout. The respondent describes this email as scathing, making accusations as to both David Patton's conduct and Jim Thorson's conduct. You're going to see email that the respondent sent after being notified by Tony Afonso of these actions, that Director Thorson sent to his chief of staff, Libby Kimsey, and to a personnel administrator within the DOA saying, we need to meet tomorrow morning at 8 a.m. and come up with a plan. So you'll see those emails as part of the evidence. You'll also see, so that's 8 a.m. You'll also see what happened at 9 a.m. because it's 9 a.m. now, after that planned meeting, that we know that Director Thorson sent an email to Scout saying, thank you for lunch. Please send me a bill. Ultimately, Scout did send him a bill, including an invoice, so we know what they had for lunch. We know, and we'll go through the list. No need to go over it here. It was about $131 per person charge for this lunch. And ultimately, we know that the respondent did send a check to Scout for 2 times that per person charge. He assumed to pay for his own lunch and 4 David Patton's. So those are the facts that are going to come out today. In addition to others, I thank you for keeping an open mind about it, and I'll rest with that. Well, I'll rest my open statement.
Chris,
Sure, thank you.
I asked you whether you wanted to defer, but there's really nothing to defer to.
That's correct. Yeah, thank you very much. I appreciate that. Good morning, folks. What I'm going to present to you in connection with my opening remarks on behalf of Mr. Thorson isn't really going to require you to make quantum leaps in logic and draw inferences from facts that may not be accurately accounted to you in the past few minutes. My client is 66 years old. He is a very successful person. He's worked in the private sector where he's had great success, and he's worked for both the federal and the state government in good positions of authority. In 2020, then Governor Raimondo asked him if he wanted to be finance director of the state. At the time, he was working for the federal government. His background is in finance. You're going to hear a lot about that, I think, when he testifies before you. So I'm not going to go into that. But he agreed to become the finance director of the state for Governor Raimondo. We were in a COVID crisis. There was a lot going on. She was reaching out to him as it related to some of the payments and monies that the state anticipated receiving and other things. And again, he can describe all of that for you. After the 2020 election, you may recall that in early 2021, Governor Raimondo was reelected, but decided to take a position in a high-ranking position, actually, in the Biden administration. The lieutenant governor, the incoming governor, Governor McKee, asked my client if he would agree to be the director of the Department of Administration, and he did. He agreed. It was approved by the Senate, and he took the position. There's more than a dozen divisions. Council talks to you about a few of them. I'm not going to recount them with you there. One of them is DCAM. There was a director of DCAM in place at the time. When he took the position, he became director in March of 2021. Unfortunately, the person in charge of the DCAM division passed away unexpectedly in September of 2021. So he needed to replace her. And there was a search that went on, there were a number of candidates, and David Patton is the person who ended up with the job. Now, you're gonna learn that my client didn't know David Patton before the search began. That David Patton was credentialed, that he was interviewed 3 times in state government by the folks that are charged with doing that, once by my client. He had a background, there was one of the big buildings, one of the big projects through DCAM was the State Health Lab, which is here in downtown, between the area and the Knowledge District that's going up. He had a background with Pfizer and some other things, and anyway, as a result, they made a decision to hire David Patton to be the head of the division, DCAM division. And Ms. Patton was working along, to any eyes, apparently doing fine, nothing outstanding, but he was doing fine. And he began in April of 2022, that's when he took the position that had been vacated in September of the prior year. He, at that point, the governor of the state wanted to reinvigorate or take a second look at the Armory project. Now, I assume a lot of you know what the Cranston Street Armory is, but if you can all just bear with me, it's a huge building. And it's built at the very turn of the century. It's one of a football field wide inside. Hasn't been occupied since 1997 when the National Guard left there. I think after that, the State Fire Marshal was in there for a while. And in the winter of 2022, it was used as a warming center. But really, it's a huge state property. The bus property owned by the city of Providence, as the parking lots that are owned by the city of Providence. So there's issues, and it's expensive to keep up. And there's an opportunity there. The governor was interested, as was Governor Raimondo before him, interested in doing something with the building. So he talked to my client about getting that done. My client talked to David Patton. Scout, as you know, from what was just said to you, already had like a foot in the door, already put some work into it and been chosen through an evaluation and a bidding process. And project, to understand, was being run by DCAM. And it was being run by David Patton. And you look at these emails, you are going to see the correspondence that takes place between the 2 principals of Scout and David Patton. He's the point person, he's who they go to. In reference to the trip to Philadelphia, he's the one that arranged the date, he arranged the time, he arranged the flights, and that's what he did. And one thing that you didn't hear, and I'm skipping around a little bit, but I want you to, this is so important, that on the 10th, shortly after midnight or sometime after midnight, he advised my client that he was going to address the issue of lunch, meaning lunch is on me, which doesn't mean he's buying him lunch, because David Patton knows he can't buy, my client lunch. You can't, subordinate can't buy someone who they report to, or they can't give him a gift of that value. So my client gets on that airplane at 6 o'clock in the morning with the understanding that the person who's in charge of the project, who runs all these projects for the state, and you're gonna hear stuff about that. I mean, there seems to be an attempt to deflect all of this to Mr. Thorson, and it's just not what's going on here. It's not what the evidence is going to show you. This project is being run by Patton because that's his responsibility, as is the State Health Building, as are many, many other buildings and projects. There's over 1,000 properties that the state of Rhode Island owns, and David Patton is responsible for overseeing their maintenance. What ends up happening is the day before, on the 9th, my client, Patton, and the other division heads under the Department of Administration end up going over to the State House and testifying before the House Subcommittee on Finance. And they present budgets, they present reasons, they answer questions from the committee members. And that takes days of preparation to get that together. My client was there, my client testified, Patton testified, and others testified before the subcommittee. Afterwards, my client took his staff, including Patton and other people who were there. So I think it's ladder 133 up here on Smith Street, very close to the State House, to get something to eat, to have a drink, and to end the day. My client did that with the knowledge that the flight to Philadelphia was scheduled for 6. I'm repeating myself a little bit, for 6 a.m. the following day out of Green. And there's two high tops that are pushed together. There's 8 people sitting there, 2 of whom are my client and Patton. There's discussion that goes on. There's some of this discussion later on is, comes to the attention of my client's chief of staff and other people who were there. That Patton is saying inappropriate things to folks there, things that could constitute sexual harassment. And certainly are something that need to be addressed. Jim Thorson doesn't hear any of this. What he hears is my client talking to a waitress about, she's not fast enough and it may affect her tip or something like that. That's what Jim hears, Patton saying to the staff there. Jim gets up about 8:15, 8:30, no one else is left yet. And he says, look, I have to, I gotta get up in the morning. He talks to the waitress. She's going to Johnson and Wales. He talks about how one of his sons went to Johnson and Wales, and he pays the bill. And I mean, that was his intention. He leaves, he just flies out of there, says goodbye to anybody who's near him, and he's done. Goes to bed. He does receive an email from his chief of staff about 10 o'clock at night. Excuse me, it's text. He doesn't see it, okay, because he's asleep. And he gets up at 3:45 in the morning to leave for 4:30, to be there for 5 o'clock, to catch this flight. What he ends up doing is they get to Philadelphia. Before they leave, my client reads the communication from his chief of staff, Libby Kimson, about the reports that she's done regarding Patton's behavior at that post testifying dinner. When they land, he then sees the invitations that Mr. Graham made reference to. One, that you're allergic to any food, you're having lunch at Irwin's. That's the first time you learn. His feet are in Philadelphia then, because he went to bed. He didn't review this. He's getting ready for this subcommittee testimony. This isn't anything he looked at before. He also in response to a second email, like, this is your itinerary, that was sent about 6 o'clock at night. He's in front of the subcommittee from the Scout folks. So that's when he learns that this restaurant is in play here. There's no allegation by anyone, and if you look at the affidavits that you have, there's exhibit 32 and 33 from Mrs. Campico as well as Mr. Abbott. There is absolutely no indication that anyone asked that that restaurant be open other than David Patton. And there's other statements that David Patton made to them about things that he has demanded that you're going to see referenced in this case. And again, there's absolutely no indication that Jim Thorson had any knowledge of that or any part of that, because this is Dave Patton's venture. This is his trip. This is what he was planning. They get into the Bach building. They met there about 8:30 or so, 8:45. They meet Lindsay, Everett, he met them before, but they have a cup of coffee, and then they begin a tour through the building. And at 11:15, the tour is basically over, but for having lunch at Irwin's. Okay, my client walks in there. It doesn't appear to him to be open for lunch. He assumes that it's opening for business because there's staff around. The restaurant is actually in a gymnasium with graffiti on the walls. It was part of this technical high school that they decided to keep as part of the ambiance or decor of the restaurant. And the chef is there. He says, I'm going to make you some things. You're going to get us, some things that my mother used to make in Italy. I'm from Sicily. He has a little conversation with them. And it's the four of them sitting around the table. And there is some staff there. There's no menu. There's no decision in terms of what to order. There's no prices involved in any of this. The chef then departs the table. He comes out with some food. Some of the staff comes out with some food. Shortly after they're there, by everyone's estimation, within 5 or 10 minutes, David Patton says, I have to go wash my hands. And he leaves. He doesn't come back for about 20-25 minutes. I think if you look at the affidavits that are presented, that are in evidence now before you, from the Scout folks, they said most of the lunch was done before he returns. So shortly after he returns, they go back to, and my client leaves the table. He's there the whole time, and he's talking to these folks. And I think one of the affidavits is they're actually relieved that Patton had left. They talk to my client. They go back to their offices, my client and Patton gather their things, they call for a cab. And they leave for, the airport. Now, my client has gotten this, communication from the night before, from his chief of staff. He's read it before he gets on the plane. He gets another communication from her while this tour is going on. And the first thing he does when he gets onto the, in the cab is he calls up his chief of staff, Libby Kimsey, and says, look, we're gonna be back. I should be back by 4 o'clock. Don't let anybody go. There's someone in human resources that deals with potential personnel issues. You know, make sure that she's around when I get back, because we need the conferences. We need to talk about this. What he gets back at 4 o'clock, he tells David Patton that he wants to see him at 9:30 on Monday morning. He wants him to do a write-up on Scout. And what he ends up doing is, excuse me, I apologize to you. Client has that meeting with his chief of staff and with Pamela Mascarelli, who's the person for human resources, who he asked to make sure that she was available. At this point, he has even more information about David Patton and his behavior the night before. On Sunday, he is contacted by the chief of staff of the government, Mr. Alfonso. He's told certain things, he'll discuss with you what they are. He's not provided with a copy of the email, which is not in evidence, but he's not provided with that portion of it. I read to him. He gets on, there's actually a family event as this is all going on, but he's making arrangements for a meeting with Ms. Mascarelli, and he invites Mr. Alfonso to it at 8 o'clock on Monday morning. And he's there, they're having a meeting. Shortly before 9 o'clock, he's in his office, and he's in there with Ms. Kimsey, his chief of staff. And another person who works for the Department of Administration's communications director, public relations director, named Laura Hart, comes in and says, look, I have a request from the press for the receipt for lunch. My client said, well, Dave said he was taking care of lunch. And then his chief of staff said, well, did you see him pay for lunch? Now, at this point, he knows a lot more information than he knew. When I ended, or he got on that plane in Philadelphia. He said, no, I didn't. He picks up the phone and he calls Everett Havertall. He doesn't get an answer. He doesn't leave a message. At 9:04, it's an exhibit you have before you. He sends an email. It says, look, can you send me an invoice for lunch? Now, he's going to tell you that his thought process is, you know, I'm not going to say, did we pay you for lunch? He's going to say, look, he's all the confidence in the world. If he ever have a ball was paid for lunch, he'll say, no, it's taken care of. But he says, I want to, you know, could you give me an invoice for lunch? And that's what he does. In his opinion, that's the way to proceed with making that inquiry as to whether or not lunch is to be paid for. David Patton comes in for his 9:30 meeting. He thinks it's with my client only. It's not. Pamela Mascarelli's there. The governor's chief of staff is there, and the governor's chief of staff basically runs the meeting. And a lot of the meeting is focused on comments and statements that were made by Mr. Patton Thursday evening after the subcommittee hearing. I think what's absolutely most important here, folks, is, you know, you focus on what the exhibits in this case tell you and how Mr. Thorson's direct statements to you while testifying before all of you under oath relate to those exhibits. And what he's telling you follows, I think, the normal chain of human events, very unexpected, very, very unfortunate. I'm going to tell you during the course of this, like I'm not a mental health professional, I'm not a medical doctor, I'm not in a position to make some of these assessments. I knew there was an issue, I knew there was a problem, And I knew it needed to be dealt with by the people within the Department of Administration or working for the state who deal with these issues and these problems. So, I'm gonna address you at the end. I'm gonna talk to you about when we're done, when we've written everything up for you. And I think that, you're gonna see that there is a logic chain of events that resulted in my client having every reason to believe that when David Patton said to him, I'll address, lunch is on me, I'll address the issue of lunch. That my client had every reason in the world to rely upon him. And you'll see, because the last thing I'm gonna end with is, you know, I think exhibit number 2 is his filing with the Ethics Commission for the year 2023, his last year in the state government. And part of that relates to, you know, companies in which you have a financial interest greater than $5,000. Take a look at those. Take a look at the other financial investments that are there. And then you're gonna have to, you know, when council's asking you to draw some inference and, in my opinion, make a quantum leap in events, in assessing what his state of mind was when he believed that lunch had been addressed and when he got on that plane to leave Philadelphia. Why would somebody in his position, with his history of success, with his resources, get up at 3:45 in the morning to drive to the airport, get on a plane, to get a rushed lunch at 11:15 in the morning? That makes, you know, like my argument to you is going to be 100% that absolutely, positively defies reason. It makes no sense. Thank you.
Going further, Commissioner Ritchie and Commissioner Browner, I noticed you've got a glare on your face. Is that a problem?
Where?
Oh, I'm sorry. I'm watching. Thank you. And also, this is gonna say. Commissioner Susan says she feels a little warm, since we can pleasure that, let's get it out. Richard, she was asking for a short break this point, before we put out any evidence. Let's take about 10 minutes and be back on the record at 10:30.
That's why it's not your. Of course, I thought.
First, bring something to your attention. So here's how a student shot there. So he won't see it. It's not a no, so it won't be able to administer no offense. Under the code, because it's a new age of registration. Right. That's not the opposite it is. So. Under the code, chair is allowed to administer the oath as is. Any noted is excellent. So this is the administer the oath for the chair. Okay, today. Yeah, I'll tell you. Yeah, where's that from? 3.15.
Are we still, we're still on, right? Owls are on.
Oh, yeah, we sure are.
Oh, okay.
Well, it says any member